Mm. We're live.
Okay, this is a meeting of the Ad Hoc Ethics Code Review Committee of the Village of Mamaroneck, January 21st at 7:05 p.m. Welcome all. Is there a motion to commence the meeting?
Make a motion to commence. Second.
Second. All in favor? Aye.
Aye.
The motion is approved. We are now in session. So welcome all. We haven't seen one another in a month, and it's nice to get back together. Happy New Year to you all. I hope you all had a safe and a restful and enjoyable and healthy holiday. First order of business is to review and approve the minutes of the meeting of December 20th. So hi, John. Welcome.
Hello.
Do we have our indefatigable secretary yet? Brian, are you on yet?
Yeah, I'm here.
No. Okay, there he is.
Yay. Hey, Brian.
Hi. Sorry about that.
Welcome. Okay, well, we convened the meeting, and the first order of business is to approve the minutes of the meeting of December 23rd, 2020. Is there a motion to approve those minutes?
Dan, weren't there still some open issues with it, with the minutes?
Brian, do we have any open issues on the minutes?
No, I thought I made the clarification that,
Yeah, I thought he made the changes.
yeah.
Okay.
We can always go back. We can, Brian, I think you've sent us a final, but if you see anything that requires
No, I
reopening it.
Yeah, I mean, I send the final after they're approved. I
Okay.
just go off what everyone's edits are.
Brian, you got to speak up. I don't think we hear you that way.
Sorry, I said I just go off what everyone's edits are and then make the changes and send them back once they're approved.
Okay. Is there a second to the motion to approve the minutes?
I second.
Any discussion on that motion? I think we've just had it. All in favor, please signify by saying aye or raising hand.
Aye.
The motion is carried. The minutes of the December 23rd, 2020 meeting are approved. The second item on the agenda is the status of mailing the letter, the ad hoc committee letter, to the Village of Amerenik employees. And Nora, I'm going to ask you to come back on now and actually address this.
Sure.
Nora has advocated strongly getting that letter out to village employees so that this now low 3+ months after our formation, we get input from the employees of the village. So Nora, could you just please update us on the status of that?
So I think there was confusion, and I think it was thought that you wanted to be able to ask questions of all of the village employees. And I think my sense is what you'd like is just to have your basic request letter sent to the employees to the extent that any employee wants to get in touch with you, they can.
Can I offer one thing, Dan?
Yes, please go ahead.
Nora,
Yeah.
I think this is critically important, and I don't know what the hangup was, but I think we should have access to the village employees. They are such a key component to this process, and they should at least have some opportunity to participate in this, I don't want to say development, but in the exchange of ideas here. And they should feel free to be able to come to this committee and express their concerns, right?
Yeah, and
No,
I think I think we're going to get to the point. I think that will happen. And if people don't want to come, they don't have to. I think there was a confusion that it was a mandatory request, not just an offer.
I don't know if it was or not, Nora, but I'll be honest with you, we're sitting on this committee, we're here a long time, and I'm not certainly blaming you, but to me, this was an easy request, and these ethics discussions should have the active participation or the ability for the employees to participate, and if not them, then through their recognized negotiating unit. And I don't know what the problem is. I'm hoping that this is rectified tomorrow, and
we have
that to me, this is so easy that it shouldn't require any further discussion.
Well, I'm trying, and we have a board meeting Monday, so I'm
All right.
hoping there's like at least a final answer by Monday.
Well, I would hope that the manager in his capacity would see, the fact that the Board of Trustees has thought it important enough to form this committee, to get them through the process, and that one of the key stakeholders here has to be the employees in the village, and that they should participate in the development of these new policies and procedures, or at least have the ability to comment on it, because they're going to have to adhere to it. And I'm hopeful that as soon as possible they get this message. Our work, I like to think, is important, and that they know we want to hear from them, and that they should be free to do so without any problem from their employer.
Well, I agree with you, and I think we're moving towards that direction.
Thanks, Nora. I appreciate it.
You're welcome, Mike, and everybody.
All right. And Nora, thank you for that update.
You're welcome.
Before we get to the next item on the agenda, I wanted to mention to you that during the course of the reading that I have done, I've seen frequent references to opinions issued by the Attorney General's office that are relevant to boards of ethics and codes of ethics. And so a few weeks ago, I emailed the Attorney General's office and asked them if they would be available to talk to me about the relationship between the Attorney General's office and village boards of ethics. And a few days ago, I got a response from the Assistant Solicitor General in charge of opinions. And we agreed to speak. I spoke to her this afternoon, and had something of a wide-ranging discussion about the relationship between boards of ethics and the Attorney General's office. And she said, or suggested to me, that she sent to me for review a couple of opinions and statutes to review that would help me understand it better, and then invited me to call her back after I've done that. So she has now sent me those documents. I'm going to review them. I will, of course, share them with you. And we can, at a future meeting date, discuss those opinions and see if they have any impact on the work that we are doing. But it was a good, I think, avenue of information to open, and which will remain open for us. And she was very, very accommodating in our discussion. So I will. That's a future agenda item which I will send to you in some detail. And so now, what else did I want to tell you before we moved on? No, I think that's it. So, oh, one other thing is before we get to our the next item, Tom Murphy has also asked for an opportunity to meet with us and talk about the Code of Ethics. So when we set up our next meeting or schedule of meetings, I will slot Tom Murphy in for an appearance at one of our meetings. Any questions on either of those items? Okay, I think I mentioned to you that
Wait,
Cindy
one-
Goldstein had requested an opportunity to meet with us. Cindy is here. And Cindy, we welcome your participation in the meeting, and the floor is yours. We welcome your comments on the code and the Board of Ethics.
All right, thank you, Dan, and thanks to everybody who I know you were having weekly meetings, so this has been a large task, but I think a really important one. And thank you for allowing me to come here tonight and have a conversation with you. I fully support a strict ethics code that is fairly and uniformly applied. And I think to make this more organized tonight, I have a few code sections that I'll go through, and I'm happy to answer any questions now or subsequently if you think of something later, if I'm not clear in what I'm saying or you're not understanding why I'm saying it. Yep.
Cindy, I'm sorry to interrupt you, but I just, Nora, I'm going to ask you to come back on. Mark Ettinger had planned to attend this meeting. He just emailed me saying that he was on, but he was knocked off.
Oh, he might have been Mike Copey. Oh no. Tell him to
I'll tell him to get back on.
Tell him to go. Let me see if I have his email address.
Can he rejoin?
Yeah, I don't know if he can rejoin when he might have come up under Mike Copey. So what I have to do is he needs to sign up go to the village website to do it. Just go to the notice thing, but I might be able to find that for him. Let me just see let me see if I have his village email address, and I'll work on that. Okay, I can send it to him. I'm going to find it. I'm going to find the link from the village website.
You have his email address? You have his email address?
I do, because he emails the board sometimes, so I do have that. So I'll get that to him.
All right. In the meantime, I'm going to tell him that you're going to try to get him back on.
Okay.
Okay, Cindy, why don't you go ahead?
Oh, okay. The other thing I want to point out is obviously the ethics code applies to volunteers as well as employees. And I obviously only know about the ethics code with regard to volunteers and specifically as a land use board volunteer. So starting with code section 21-4C1. That is the, this is a big one. Let's just jump right in, right? This is talking about recusal and the generalities that apply to it. 21-4C1.
Yeah, I'm going to try to get there.
Okay, okay. It's probably helpful if we have it in front of us.
There it is.
Okay. So this is talking about acting on a matter or failing to act on a matter. Those seem like contradictory statements. So I think a little bit of tweaking there would be important, but really the gist of this, to benefit persons financially or otherwise. So what is otherwise? And then we talk about give the reasonable appearance of a conflict of interest or impropriety. Reasonable to whom? I think this is one of the areas that when this law was enacted, at least the legislative history that I've reviewed, would benefit greatly from having a library of information or opinions over the years from the Board of Ethics. There's no guidance. So what we rely on then is regular case law talking about what's reasonable and the reasonable person standard. So this is a very garbled section. I don't think it really provides any guidance, and it's really subject to misunderstanding, shall we say, on a regular basis. And if anybody has questions, stop me, but I'm just going to keep going because I'm
Keep going.
okay. 21-4N. It's talking about disclosure of interest in legislative and official action. It talks about
What was that section again?
21-4N.
Let me get there. Sorry, I've got to move this block over. There's N.
Okay, it looks like you've already started working on this. My issue with this is talking about why would a land use board member have to inform the Board of Trustees in writing? I've been on land use boards now for 7 years. We always took our advice on recusal and other matters from Land Use Council. We do our recusing in front of the applicant at our publicly held meetings. It is recorded in the minutes. It is recognized at that time. I don't really know the point of having to appear. Does that mean I have to go and stand in front of the Board of Trustees and tell them I'm recusing on an application that may have already finished going through the land use process? Maybe it was a one-time appearance. It just seems to make no sense and is very cumbersome, and actually can be used to trip people up for no reason. I believe the standards could easily be announcement of a recusal, and the reason for that recusal is done at the land use board. It has no business in front of the Board of Trustees, in my opinion.
You're saying that a statement of recusal merely, you believe it merely needs to be made on the record at the relevant board?
Yes, at the time that the application comes forward, the person recused. This is what we've always done. I mean, this is standard practice for 7 years that I've been involved with this. You state that you're recusing, the reason you're recusing, and then you remove yourself from the application. It's pretty straightforward, but to try to put an extra layer in that, to appear in front of the Board of Trustees, it's not so hard during COVID, you zoom in, but it used to be you'd have to go and tell them why they're not interested in a land use application. It's just cumbersome and unnecessary. And if it's going to be a violation if you don't do that, I mean, there have been recusals in the past 3 months on the planning board. I guarantee you, no one has appeared in front of the Board of Trustees. It's not reasonable and not necessary.
Would it cure your concern if there were a point of view that the Board of Trustees needs to be informed? Would it cure your concern if this section were changed from informing the fully disclosed on the official record of the board to sending a written notice via certified mail.
I still think that's way too cumbersome for volunteers. The Board of Trustees gets copies of all of our minutes. They can watch the tapes in real time. Frankly, they should stay away from land use applications. It's not their business. They're legislators. So I just don't think it has a role in front of the Board of Trustees. Everything is above board and out in the open at the land use board meeting.
When somebody recuses, do they, I mean, obviously that would have to be recorded in the minutes, correct?
It always is the minutes that we review, yes.
So,
It's on the tape.
yeah,
It's very public. It's not hidden in any way. The only people that need to know are those watching the land use board meetings. It's just an extra step, and it's looking for a gotcha moment with a land use board volunteer.
Okay,
Can I make a suggestion on this? Let's take a look at the state's model code and see what it says.
yeah.
good idea. That's easy to do.
So my next section is 21-5B.
All right, let me get there. Hold on, please. 21.
Dan, could I ask one question before we jump to that?
Please do.
Cindy, it's Michael. Just in terms of that notification, I hear what you're saying there and the separation of legislative and the land use. Would you feel if that notification went to the Board of Ethics, because ultimately they have a role, I would say, in conflicts, right? And conflict resolution with appearances, would an email to the Board of Ethics, an official email saying that I've recused myself on this matter, would that be too much of a burden?
I think it is. Recusal is a very personal matter, and you can recuse because you need to recuse based on the code, or you can recuse because a personal falling out, a relationship in the past, something you don't feel you can be fair and unbiased when you're looking at the application, has nothing to do with any kind of financial compensation. I think it's a burden for the land use board members, and I think it's a burden for the ethics board to have to look at that. Frankly, it's too late at that point. The person's recused. There's no question. There's no ongoing issue. It seems superfluous to include them in the process.
Okay, but I also looked at N somewhat differently, and maybe I'm off base with this. But I took the N, the section we were just on, to be that somebody would have to disclose a potential conflict, and you're not sure if it's a conflict, and you should or should not recuse yourself.
No. I'm talking
The
about,
way I
yeah.
read that, because it's at the bottom section of N refers to a decision being made.
Well, when an application is opened, a public hearing at the planning board is opened, that would be the start of a decision to be made eventually on that application. But
No, I took the decision to be made was, but you've disclosed whatever, there might be a conflict of interest. Whether it be the Board of Trustees or the Ethics Board could come back and say, no, this isn't a conflict and you can go forward.
no,
That's
no.
the way I took that.
Once a recusal has been made by a board member, regardless of whether or not somebody feels that the recusal is unnecessary, that's,
No,
you don't
John,
even have
took
to
that-
disclose, you don't have to disclose what the issue is when you recuse. You can choose to.
Right, but I took N to be that you hadn't recused yourself yet. So I may be off in reading this.
Well, then it's even worse. You're right. The language, I think, is very obtuse. Then it's even worse because a land use board is looking at an application. Sometimes they dispose of it the same night they look at it. So for all this to happen, the application's gone. It's been approved. It's over. So to have to go to the Board of Trustees, it's the timing doesn't work. And that's why an understanding of the land use board process is really important for the Board of Ethics members. I'll get to that later. But recusal can't be forced, and it can't be you can't be forced to recuse, and you can't be forced not to recuse. It's a personal decision. Obviously, there are guidelines in the code and your own moral compass, but that's it. So I probably looking at the model code would make a lot of sense, because I'm sure we don't need to reinvent the wheel here. My next section is 21-5B, which is the disclosure forms. I watched the hour and a
Excuse me,
half.
were there any other-
Oh,
Sorry, Cindy.
all right.
Were there any other comments on that? Anyone want to add anything else to that? Okay, thank you, Cindy. Please go ahead.
21-5B is the annual disclosure form, and I watched the hour and a half joint meeting that you had with the existing Board of Ethics, and a lot of time was spent on the fact that people don't comply with this. As a land use board member for 7 years, I've filled out my share of forms. I have one sitting on my desk right now. I can tell you that in at least 1 year, and I believe 2, the village distributed the wrong form, a prior version, and that wasn't sufficient. So I filled it out, I had it notarized, I dropped it off, and I was told I had to redo it. So it's not just that the volunteers are ignoring this or taking it lightly. There have been, multiple issues trying to get the paperwork done. And I am scratching my head about why this is so difficult. One of the problems, especially now during COVID, is having it notarized. I don't understand the point of that. Notarization does not validate what's contained on the form. All it does is validate that the person who signed it is the person they say they are. I think the chance of having someone submit a financial disclosure form on behalf of somebody else, as a bogus prank is not likely. Why do we need to get these notarized? You'll get them back so much quicker if they're not. So I would recommend that that's something that would help. The other thing is, at least when I was chair of Harbor Coastal Zone Management for 5 years, I badgered my volunteers on the board to get the forms done, because I understood the gravity of it, and they can be removed from the volunteer board. I also don't know why it takes 5 Board of Ethics volunteers to work on getting these done. It seems very inefficient, and I think there are better ways to handle it. So that's all I need to say on that.
Any question or comment on that? All right, please go forward. Go ahead.
21-7D.
Okay, let's get there. D. Okay, here we are.
Okay, so this is, it's really, I guess, D6, if we want to be really specific about this. Talking, and it looks like you've done some work there, because I guess we all know that registration for a particular political party doesn't mean that you're active or believe their tenets or anything else. I understand why you want to make it look apolitical, and that makes sense. But we're a small village, and it's probably not the political registration that's so important, but rather the political activity. Maybe in the past 3 years, not having been a party chair or a district leader or a candidate for office. I think there might be better, more specific and more meaningful things that you could do to talk about the political situation. Because we do know this is all very political.
Any comment on that? Cindy?
Sorry, I guess I just have a comment.
Go ahead, Brian. Speak up, please.
All right. So I guess the idea of having no more than 2 members, like you talk about other factors like being a candidate, I guess that's just like too cumbersome, I guess. So I guess it just cuts the tree off at the legs, to just have no more than 2 members of the ethics board. Like, it's simple and straightforward, instead of having like a more factored approach. Like, oh, if they were a candidate, if they were, you know what I'm trying to say? I guess it's just more straightforward, just having no more than 2 members of the ethics board shall be registered in the same political party is like more straightforward than having a bunch of like 7 factors or so.
And this is also very much in line with the model code.
Yeah.
Yes.
Well, for, in the old days, very often there would be a member of the clergy on the ethics board, which I think is probably a good idea. Does it really matter what party they're registered in? You know, it was just a suggestion, because I think, you know, it's substance over appearance, because it's more your activity. You can be registered anything you want to be. It doesn't mean that's what you are. And it looks like you're trying to deal with last minute registrations. That looks cumbersome too. I'll just mention that. But it was just a thought. 21-10C8.
Okay.
Do I have 21-10 C8 is talking about, okay, to provide, okay, so you're transferring this to the village manager.
Right.
Okay. I mean, I guess that's fine. The problem is the training of the land use board members. I mean, I think it would be critical. I think it would have prevented a tremendous amount of money and heartache and anguish and time and effort if there actually had been communication from the Board of Ethics to the land use boards. Volunteers really need to know what the Board of Ethics thinking is about how they will interpret the code. And I don't know how that can be offloaded to a manager's office that doesn't have a role in investigating or following up or providing advisory opinions. For example, I was told after the fact that the Board of Ethics was concerned about people opining and participating on land use board applications if they lived in the notice area. The notice area is arbitrarily determined by the Board of Trustees. And if you want to do a development or improve your property and you have to go through the land use process, the code tells you that you must notify your neighbors within a particular radius. That's the notice area.
What code are you referring to?
The building
What
code.
are
The village
Sorry.
code of Mamaroneck
Okay.
specifies
You mean-
if I want to put in a swimming pool and I'm disturbing a certain amount of soil, I have to notify my neighbors within a 200-foot radius of my property that I'm doing this. And I have to tell them when I'll be appearing and in front of what land use board, so they're included and they understand what's happening and they can come and say this is good or this is bad, and it's in you know, in the interest of transparency. But the 200-foot notice area is arbitrary. The village board determines that. It means nothing in terms of whether or not someone needs to recuse. But if the Board of Ethics decides that that's something they want to scrutinize, I think it's only fair that they communicate with the land use board volunteers and say, you know, we see this could be an area that is an issue. This could cause a conflict of interest if you are in the notice area. So proceed
Cindy,
accordingly.
I'm trying to think of how you put this in the context of the code of ethics.
I mean,
You're talking about the village code and a notice requirement.
I mean,
And
sorry.
I'd like to just find out how that translates to this code.
Sorry, I think she's talking about recusals.
Well, I guess I can explain what I'm talking about. This is an example of how training of land use board members must be done by the people who are enforcing and have the most understanding of the ethics code. So if they are thinking, that was just an example, but I think, I don't know how the training could be done by the village manager. It might be able to be done by land use council. That would make some sense to me.
Okay, Cindy,
Yes.
on the topic of training, we landed here because this is training for all village employees, committee members, et cetera, for 100%, not just a land use board. So you're talking about a very specific need, which is valid. But to have a volunteer committee, such as the ethics board, be responsible for training all village employees did not make sense.
Then that makes sense to me. The employee, see, I've sat through trainings on the state law, which is fine, but it's mostly talking about gifts and employee issues. We really need to break this out then for land use board members, because it's certainly been pointed out, that's where the pitfalls are. On the budget committee, you're not going to have a problem, I suspect. But it's the 4 land use board that are in danger if information is not communicated from the Board of Ethics to those members as to how this code, which is very vague in some areas, as it may have to be, how do we avoid the pitfalls? And we don't know what they're thinking unless they tell us. So maybe there's a separate training by the ethics board, or it doesn't have to be training. It has to be an occasional communication. Again, 7 years on land use boards, I never heard from the Board of Ethics, never. The village clerk's office sent out the financial disclosure forms. There were no communications.
Yeah, I don't know that it is the role of a reactive Board of Ethics, primarily a reactive role, to be the educator. And we discussed this at great length, Cindy, and I'm not saying we have the answer, but we were concerned that a volunteer board was impressed upon with the responsibility to carry out education. And Ellen's research, and I think Jocelyn also was involved, is that there are oven-ready kits that can be used to, and seminars that are available, and commercial products that can be used to educate those who are covered by the Code of Ethics. But we were seeking to take this burden off this affirmative burden off the shoulders of a volunteer committee.
Well, but again, here's the problem. And I heard a Board of Ethics member say, well, we should just all get training. That's fine. But that will be on the state code. It's not going to be on our local code. Our local code is different. And if we don't have someone who knows our code helping us with it, we're going to have more situations that really should not happen. So I don't need a general ethics training. I need to know how this ethics law affects land use board members and what the expectations are, because the expectations have been not uniformly applied. So you can't look around and say, oh, well, so-and-so did that, that must be okay. And then somebody else does it and it's not okay. So we need specifics on our code. There's no prepackaged product for us, I suspect.
Yeah. Any other questions, comments on that?
Yeah, can I just ask, Cindy, are you recommending a very proactive approach by the Board of Ethics to be included so that they're out there monitoring in front and offering guidance and opinions unsolicited?
Yes, I am actually. I think they should prevent problems from occurring, not play gotcha. I think that at least under this code is their duty. They have lots of duties. I mean, this is a very task-heavy code for the ethics board. And when they don't do it, I think we see the results because none of us are mind readers. And if they're not more proactive, then the code's going to be not applied evenly. So that when one person does something, it's okay, and somebody else, they get caught. It doesn't make any sense to me. If we don't know what the standards are, like what's a reasonable appearance of impropriety? Reasonable to whom? Someone who understands the application, someone who's a lawyer, someone who's, we're supposed to be building a compendium of knowledge that we can go to figure this out. So yes, I think they should be more proactive rather than just sitting back and waiting for someone to trip up.
Cindy, one of the things we're working on that we'll spend more time on when we're done with our edits is something called a Racy Matrix. Because one of the things that jumped out at me reading the code initially, there was no accountability, no ownership. And you're right, there are lots of tasks implied throughout all of this. So this Racy Matrix is taking all of these sections and saying who's responsible for doing it, who's accountable, who needs to be consulted, like the village attorney, and who needs to be informed. So we're working through that because some of
Ellen has,
Yeah,
she occasionally phrases, don't take it personally.
it's my Wi-Fi. Ugh,
You're back.
I'm back. Do I need to repeat anything?
Just the tail end.
It's some of what I think Cindy has raised is more process oriented than code.
It may very well be, because of course that's easier to do than change the code. And as I said in the beginning, land use board members and other volunteers, it's a very different animal than village employees and that kind of thing. So
Yep.
Some of the things
And-
apply and some don't.
And also the land use boards have decision-making abilities, whereas the budget committee is essentially an advisory committee, whether it's constituted as an advisory committee or, they don't have the authority to spend or make budget
We don't have
decisions.
the authority to do anything.
Yeah.
I mean, that's what it comes down to.
No, but I mean, and many of the committees in the village are like that, except for the land use boards.
Yep.
So there is a differential.
So yeah, I think to have a code that is actually respected and workable, it has to be a little more proactive.
Okay.
All right. Next,
Just going back to that issue that you just raised, though, I mean, I think some of having been on the board when we passed this, when this code went into effect, the thinking was that there would be a library of opinions, an ethics board, advisory direction to be given to employees, or as they made recommendations or judgments on specific issues, that would go into essentially a binder, that could be referred to by people. And, I've never seen nor heard of any of those decisions getting put into a binder that could be referenced for anybody. Which I think, if you start with the small stuff and work out from that, as the ethics board, they could have been a resource, more of a resource for people than they may have been in the past.
yes, and that's, I mean, in the absence of guidance, I've always relied on the land use attorney, because that's the person who's there to keep us from getting into trouble or getting the village into trouble. So nobody wants lawsuits. Then on to section 21-13A about investigations. Okay,
Okay,
All right. I'm all in favor of a sworn complaint. I think it's important that somebody in good faith signs their name and swears an oath that what they're saying is the truth. And I'm always concerned when there are anonymous tips, because no one then has the opportunity to evaluate those tips in context. I know when I was participating in the hearing, both hearings, I was under oath. I was sworn to tell the truth. No one else is sworn to tell the truth. I do understand why the Board of Ethics would need the ability to start an investigation or inquiry on their own without a sworn complaint. But the problem with that is that if they're the genesis of the complaint or the matter, they have a vested interest in proving themselves right. I believe a more fair solution to that would be if there is no third party sworn complaint, which would be preferable. The board could pursue anything on its own, but one of its members would have to file a sworn complaint and then recuse on the matter as it moves through the Board of Ethics process. Somebody needs to be held accountable, and it has to be serious. I mean, I read the Board of Ethics report. It sounds like they get a lot of really ridiculous and trivial, often political, jabs. It's used as a weapon. I mean, I think that's what the problem is. The Board of Ethics has been weaponized, and their time is not well spent parsing through petty complaints that should be handled another way. Because if I didn't know it already, which I think I did, I've certainly learned how damaging ethics issues can be to individuals. So I would urge you to think long and hard about someone should swear a complaint based on their knowledge, their actual, some research into the matter, not just a bunch of anonymous tipsters, because it's a really dangerous road to go down. So that's my recommendation with that.
questions, comments on that?
Seems fair.
Okay, thank you. Yeah,
It's still in the same section. It's the S word, the subpoena word. I will tell you that it's very intimidating to receive a subpoena. There was no attempt at keeping the subpoena confidential when it was delivered to my house. It came from a staff member, not even in an envelope. It was not just for documents, which actually had already been turned over, but it was for my husband's attendance at the hearing. There should be some requirement that some care should be taken with a subpoena. It is very easily used as a bludgeon and an intimidating device. I don't want to go into the details of my case, but it was absolutely unnecessary. Everything had been agreed to, and yet we get a subpoena.
well, Cindy, we need to get away from that. We need to talk about subpoena as a process of the board. Fine, but let's take it out of the context of your case.
That's fine. I'll just tell you then. It's a very aggressive thing to do. I don't think it's necessary. I think there's too much opportunity for it to be misused. And if something isn't delivered, then I think the board would go about its decision-making process, noting something wasn't delivered. You can make an inference when you're looking for information and it's not produced.
Are you saying that a board of ethics should not have subpoena power?
I am.
Yeah, it is in it's so empowered in the state law, and it's fairly common in codes of ethics, and it's fairly standard in order to empower a board to compel the production of testimony and documents, but we hear
Dan,
you.
if I can offer, I think that there should be we should mention how this process should be utilized, right? I think we've got to discuss that. The use of subpoenas, the delivery of subpoenas, the privacy associated with this process. I do think it's something that we should be able to discuss as we go forward.
And
Okay.
also the possibility of, as part of the process, in the event that there isn't cooperation, then the subpoena power can be instilled. But if there's cooperation, that whether it's required. So something in the process, confidentiality, appropriateness, and maybe if there's something that we can discuss about only in the event where there's not mutual cooperation.
Cooperation's in the eye of the beholder and can be easily ignored. The fact that it's only been used evidently twice in my matter. I only know of one subpoena in my matter, and that came to my house. The other one I have no knowledge of. It's the only time it's been used. I don't think we need it. It's not
Cindy?
used. Yeah,
I'm sorry, can I ask you a question?
of course.
So I believe you said you don't think the ethics board should have the power to issue a subpoena. Do you think anybody should? The village attorney, or where do you think that lies?
You mean in an ethics matter, should the village attorney be able to issue a subpoena?
Right, who do you think should be able to issue a subpoena?
No one, not necessary. It's never been used before my case, and I was completely cooperative. I'm sure there are others who would disagree, but I have the paperwork to prove it.
Well, what happens in the event a subject of an investigation refuses to comply?
I think it counts against them. So if they refuse to come in for a hearing, let's say, so you find against them. It's very simple. They have all the power. You know, what we do in the land use boards, if we don't have complete information, if the applicant hasn't provided what's mandated by code and what we need to make a decision, we deny the application.
You're saying take an adverse inference as opposed to attempting to find out the breadth of what could be an act of misconduct.
You've already tried to find out the breadth of the active misconduct. You've asked for the materials. You've tried. If somebody won't give it to you, you have no choice but to make a negative inference. It happens all the time. We do this at planning board meetings. We need information. They don't give it to us. Doesn't look good. It's like pleading the fifth. Doesn't look good.
Okay. Any other comment, question on that?
Yeah, I mean, I would just say that, you know, I understand where Cindy's coming from. I mean, the inference would be, I mean, and I understand the point that Dan is trying to make, but if the misconduct is perceived to be so great, then whatever information the ethics board has can be referred to somebody in law enforcement. You know, if the perception is it's such a crucial and critical issue and the level of misconduct is so high that there's, you know, a concern about it's not just a minor issue, it's a major issue. There's the district attorney that could be given this information.
The ultimate subpoena power.
Right. I mean, I think there are ways to address that.
Okay. Let's move on. Cindy, any next section?
Let's stay right there. 21-13E. I did see that you had some changes in that because certainly, you know, the way the current code is being interpreted, Board of Ethics members are above the law. There's no way to challenge or make a complaint against any of them. they forward the complaint to the village manager and it goes into the recycle bin. So I'm happy to see that there seems to be some accountability there. That would be much more fair. Let's go on to 21-18A2. I think we've covered this, talking about training and education. And again, I don't think the village manager can do it because it can't be a cookie cutter. I think you get competent land use counsel, not, with a specialty in municipal ethics, to look at the code and maybe make a plain English guide for land use board members, extract what we need to know from there and just circulate it. Maybe you don't have to do training on a regular basis. You would have to update it, but you do it once. It's not an expensive process.
Cindy, can I ask a question? It may have come up earlier. How much training did you receive in 7 years on land use boards?
0. Well, I got my own training, but 0.
There was no ethics training or any documents, nothing that was sent to you?
I mean, from about the village code?
Yeah, about the village board of ethics, the village ethics code.
We were given a copy of the code when we had our initial appointment, and it was suggested that we read it. I don't believe I ever received anything else from them. As I said, the financial disclosure form came from the village clerk's office. So
Okay.
nothing. So
Cindy, what we're recommending here, which addresses your previous concern about the village manager doing training, is that the ethics board be involved with the material prep.
okay,
Because clearly the village manager can't do it. But we're saying the village manager is responsible for rolling the training out, not the ethics board. There's a difference between content versus administration.
and that makes perfect sense. I mean, I don't even think the average ethics board member really understands municipal ethics. It is such a specialty unto itself. It seems dry, but it can be interesting.
But Mark Davies is right here at Fordham, I believe.
Yeah, I mean, there are maybe 3 municipal law ethics experts in the state.
Yeah.
He was one of the authors of the articles that I've been reading in this, which is always by my bedside, I should add.
Insomnia.
I've read a lot of his work.
Mark is evidently, he's written the New York City Code. I think he's quite brilliant on this and kind of makes a dry subject interesting.
Yeah, I was in email contact with him before we began the committee work. He was very gracious in offering his support, but he said, first read my essays, which I've done.
They're available on Amazon. So 21-22, the whistleblower protection. There's a lot of conversation about that with the Board of Ethics. And I do scratch my head.
Sorry, where are you now?
21-22. The whistleblower protection.
Yeah.
Okay. I applaud whistleblower protection for employees reporting violations on their peers or their supervisors. It doesn't really work that way with land use board members and volunteers. No volunteer has any authority whatsoever over the hiring or firing of employees, nor do we have any method of retaliation. It's just ridiculous. So I don't believe, as I said, I don't know that you need to change the code, but as I said, I know the current or the former ethics board was very concerned about whistleblower protections, and it doesn't make any sense.
Did you have a recommendation that section, or just, you were just commenting?
Well, what you could do is take out volunteers from that discussion, because that's not a concern. If a village employee wants to file a complaint against a land use board member, they might have other things they're concerned about, but whistleblower issues would not be among those. We have no
Any
authority.
questions or comment on that?
Cindy, are you saying you could take out or we should take out?
If it were me, I'd take it out, because it's muddying the waters and implying that land use board members and volunteers have some kind of authority that they just don't have. I can't retaliate against anybody.
Yeah, but isn't all the whistleblower protection doing is keeping the person who's filed the complaint anonymous?
So if a village employee, oh, sorry, Cindy, go ahead. Sorry.
No, go ahead.
So if a village employee makes a complaint against a village board member, are you saying you should take the board members out from being able to make to have whistleblower protection?
No, I'm just saying that you're giving protection to somebody filing a complaint against volunteers that couldn't possibly retaliate. That's the point of the whistleblower law, is to prevent retaliation, either by demoting the person or firing them or whatever. We have no control over that.
But couldn't theoretically withholding an approval on a land use issue be retaliation?
Against what, the village planner?
No, I mean against an employee. Say an employee has, well, I guess they're doing it as a resident and not as an employee.
Right, so let's say I filed a complaint and then I appear before the land use board. Somebody could say, oh, she filed a complaint. I'm not going to approve this.
The likelihood of that is really slim to none. I just don't. That's not whistleblower protection. That's just like decency and integrity, and hopefully we don't have to legislate any of that.
Yeah, I was thinking about that. It's really not whistleblower protection, but it is a problem. You know, there is a potential problem there, but it wouldn't be covered by the whistleblower law.
Right. I mean, we could add a part to the code that says, don't be a schmuck about it. It's act like a decent person. And frankly, if they're thinking that way, they shouldn't be on the land use board. Just going back for a sec, I think I'm done with the code sections. I just had a few other comments.
Sure.
I think it really would be helpful if the ethics board was more proactive, because what happens is that, I know they've said they don't watch the board meetings, and who would want to? I understand that completely, to try to find, problems with people. But when some similar situations are followed up on for one person and not another, I think it's really undermining the ethics code. It appears as if certain people aren't being scrutinized and others are, and you really need to have an even application of the ethics code to make it respectable and make it something that is adhered to. And it's just a problem to not have clear standards and then hold everybody accountable if those standards are violated. So the other thing is, I think it would be really helpful if the Board of Ethics had an understanding of the land use process. There's a big question. They don't understand ministerial acts. They don't understand discretionary acts when it comes to the process and the time frame of the process. So I'm concerned that they need to sort of, because the issues come up with land use board members, and it is a little bit different how we have to operate. I think it would be helpful to try always to get at least one Board of Ethics member who has served on a land use board, it's a frame of reference that would be really helpful to them, I think. The question of alternates, having alternates to land use boards in case you get to a situation where many people have to recuse for whatever reason. I think the concept in a small village like this just shows a profound lack of understanding of the land use board process and what we have to learn and how we have to educate ourselves. And, you know, frankly, it's insulting to suggest that any warm body can be in a land use board chair and we're all fungible, we're all interchangeable. You know, we take a lot of time and we study and we have experience when reviewing applications. It seems that people aren't, you know, running to clamor onto these boards. It's a lot of work. And I don't imagine that the idea of finding 2 extra people for each of the land use boards who might never, ever be called to hear an application would be something that we really need to waste our volunteers' time on. So I just don't think that that's a workable solution. I don't think we've ever gotten to the point where so many people had to recuse it was a problem. But I just can't see that alternates would work.
That's not Board of Ethics, though. That's land use law.
That was,
You're talking-
I think that was a recommendation that the Board of Ethics had made.
When they were proceeding with trying to get the code changed for the notice area to be the measuring rod for recusal on a land use board, they were also then suggesting that alternates could be, you know, the code could be changed so that alternates would be provided for all the land use boards as a way to make that palatable.
Because there would be a higher number of recusals because people would be living within the notice areas.
The absolutely arbitrarily decided notice areas in the code that may or may not have any impact on the person's property just
Right.
because they live in the notice area.
When we were writing this ethics law, Janet Insardi was our attorney. She directed us, you know, the discussion of whether or not we could legislate recusal in notice area came up. And Janet basically said, look, if you do that, what you're doing is actually limiting the power of the person in a land use seat by basically saying they have to recuse if they're in the area. And there's no precedent for anything like that in New York. At the time, I don't know if there is now, but there was no precedent for that. And frankly, no legal basis for that. And so that's why we didn't do it. And, you know, I understand my concern with the whole idea, and we're getting sidetracked here, but with the whole idea of alternates is I get concerned about people board shopping. You know, they go to a land use applicant goes to a board and basically finds the most favorable 5 people or 7 people and tries to figure out how to get those people to be on the committee that sit for their decision. So I think that's it opens up another can of worms that I don't know that I would want to be involved in, but hopefully the Board of Trustees addresses that clearly.
So I really have nothing else except the E word. It may be a new dirty word, but it's a serious matter, and reputations, livelihoods, all these things are at stake. And so that's why I'm particularly hopeful that a revised ethics code and all of your many hours and hard work on this will really restore public confidence in this process. And I certainly hope frankly, it never has to be implemented all the way to a disciplinary hearing again. So I'm always available if anybody has any questions, but
Dare I ask, what is the E word?
ethics, ethics.
Oh, okay. Sorry, I'm a little dense on that one.
No, it's,
Thank you, Cindy.
Any
thank you.
any questions for any further questions for Cindy? If not, Cindy, thank you very, very much. This has
Thank you.
been very helpful.
Yes,
Appreciate
thank you,
it.
Cindy.
My pleasure. Thank you for taking the time and continuing, because I can turn this off now and you guys keep going.
All right. And we excuse me, invite you to follow up as you see fit in communicating with us in writing, or if you want to come back and talk to us, you are welcome to do so.
Great. Thank you. Thanks so much. Good night.
Okay.
Good
Good
night.
night.
Okay, we are at the 8:13 p.m. mark, so I think we've probably should wrap up now.
Can I,
And-
Dan, can I just go back to one issue that Cindy did raise, though, about notarizing the disclosure forms?
Sure.
My opinion is, I think notarizing those forms is important. And I know it requires an extra step, but I think it basically, it prevents somebody from saying somebody else filed, in inaccurate or inappropriate disclosure form on their behalf. I agree that there's very little likelihood of that ever happening. But
I second that.
Yeah, but
suggestion.
John,
Can I offer?
that's not part of the code. It doesn't state that.
it does state to be that the disclosure is
I didn't see that, so I must have missed it.
I believe it does.
Could I say one thing on that? And I think we need to make it, we want it to be easy for everybody. But if the document had a 21045 notice where they were signing it, knowing that if it contained, a false statement, might that suffice? And that, somewhere at a meeting, they offered the document and said, yes, I'm in compliance, I've submitted this. And, it might just eliminate the need for the notarizing of this. Right. So I think that there might be other ways we can do it too, without requiring somebody to go get it notarized.
And in reality, Cindy was right. The only thing a notary does is validate your signature.
And if the person validates it in person in some fashion, and, there's, like I say, a notice there, the filing of which would create a crime. So I don't,
Okay.
I hear what
All
you're
right.
saying,
Yeah,
John. I want to
mean,
keep it tight myself, but on this one, I'm like, I think there's other ways we could probably have them address it.
okay. I'm more than happy to listen and, certainly understand that point that it, having it be more complicated than it is unnecessary. But I just worry about somebody who's got a grudge who, intentionally files John Hofstadter's financial report erroneously on purpose,
All right, I think we discussed it. Maybe we can find some other way.
Yeah.
If it's notarized. Could I offer one more thing for the meeting? Were we
Please.
done yet or no?
No, keep going.
I just, if I could ask, I know that we had some email back and forth about people coming to this meeting and commenting and not commenting, to the extent possible. I know we have to have some discussion back and forth, maybe by email, but anything that gets along that line, I would be more comfortable. We had these discussions here on the in the forum, right? So that the public could hear, what we were talking about. And I would offer really that anything we do, we have the Zoom now, and I'd like it to be done on the Zoom.
So that the person that just sent that email was an attendee, and he said he couldn't raise his hand. I don't know why he couldn't raise his hand. And I don't know if there's any other, there's he's still listed as an attendee. I don't know why. I will check and see, you know, with my Zoom mentor about why that might or might not have happened.
I have no idea what you're talking about.
So I think an email just went to the committee from Mark Ettinger, who couldn't raise his hand, and I didn't see I mean, I've been watching, I didn't see the hand being raised, so I don't know what that, you know, I don't know if you want.
Yeah, but he was able to unmute himself, correct?
No, because he just, this is, if inadvertently, people used a link that was a panelist link as opposed to the public link. So he was able to get in during the public link, but I have to unmute them and I didn't get a sign that he was unmute. So I'm not seeing the hand being raised. So, I mean, I think you guys have to decide whether you want the public to speak, and if so, I'll figure out how to make that happen.
I sent my link to Mark and to Cindy and to Debbie Chapin, not knowing that that was not the way I should have invited them to the meeting. So that's what knocked them off at the start,
Well,
and nor then got them back on.
I got just Mark back on because we had the double names, and so I thought there were two Mike Copies, but one Mike Copie inadvertently it was just confusing. But once, I think it's a security issue, once a host has knocked someone off, the presumption is it's somebody who's Zoom bombing, which was not the case. So we'll have to figure this out for next time. And I assume that the attendee could speak if you wanted them to.
Is there any way to invite them back right now via the public link?
It looks like Mark Ettinger's on right now, so I'm going to allow him to talk. And he has to, looks like he has to ask to unmute.
Mr. Chair, just, I know we were talking and it's late, but in light of that they are here and they wanted to participate and we've been asking for participation, you know, I would ask the rest of the committee if we could hear these other members of the public who are looking to talk to us.
I agree with that.
That's
Mark, if you're on.
He should be able to unmute himself, but let me try one more thing. Okay, now he's listed as a panelist. He should be able to speak. I don't know. I think if Mark unmutes himself, he can speak if he's still watching. Maybe not. Maybe he's not watching.
He's showing on my screen here.
Yeah.
It's his name. And Mark, if you can just unmute yourself, maybe.
No, he says he's trying now. I think he has to unmute. I don't know. Now
While we're waiting, any discussion on when we would want to start these meetings again in the future?
That's a good point. Thank you for that, Mike. How is this day and time for everyone, or is there a preference for another day and time?
This day and time works for me personally.
Brian, I can't hear you.
Sorry, this day and time works for me personally.
I'd prefer a little earlier.
I can do whatever people want to do.
Brian, could you do 6 o'clock?
I mean, I can, I guess.
What about 6:30 as a compromise?
I mean, it's not
Do
just
some of us older folks a favor, Brian. Right?
Or dinner.
Right,
Yeah.
I haven't had dinner yet.
Well, yeah.
What can we,
Can we do 6:30 as a compromise? Could that work?
Yeah, that's fine then. I mean, it's not just up to me. Everyone's like looking at me.
You know what? No. I'll make you dinner. How about that? I'll make an
Brian,
extra portion.
Put that in.
Brian, you are a young working lawyer. We want
Yes.
to we're not looking at you because we really want to accommodate you. We don't want to get you in trouble with your firm.
Right.
I guess 6:30 is okay.
All right.
Thank you.
So is Thursday good?
There's
Yep.
All right. So we're going to meet. Let's set 6:30 Thursday as our regular meeting time. And I'm going to, unless I think if we can't get Mark on now, I'm going to invite Mark to the next meeting.
Okay, he seems to have hopped off, so I think, and I'll check. I don't know why he couldn't unmute himself. I can only allow them to unmute, so.
But I just took a quick look at his email and a good chunk of it. I mean, some explain some aspects. But some of it was specific to Cindy's case, and we're trying to stay away from that.
All right. Mark is available to come to another meeting. I think he's basically stopped trying to get on. So I will invite him to the next meeting, which will be next Thursday at 6:30
Yeah.
p.m.
Well,
And I-
so he should, but what he should do is, I think, get on with the public link. Otherwise, he has to be sent a separate link by Sally. We all have separate link. I mean, I have a host link. Everybody has separate links. So when
All right.
it's shared, that's where there's a confusion.
I got it. So let's, you and I, Nora, figure out how to make
Okay.
sure he's logged on correctly the next time, and he gets his day, evening.
Okay.
Okay. Any other matters before we adjourn? If not, thank you all for your patience this evening. It's a long meeting, and we'll take a motion to adjourn.
I make a motion to adjourn.
Second,
Second.
all in favor?
Aye.
Aye. Thank you all. Have a wonderful balance of the evening, and I'll be in touch with you guys, and we'll meet next week. Thank you.
Thank you.
All right.
Thank you, Dan.
Thank you.
Thanks, Dan.
Bye.